Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson. I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the question or chat box and they'll be brought up at the end. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Good morning, everyone. Welcome to The New Normal, your go-to source for insightful discussions on the gaming industry and critical issues affecting Native American tribes across the United States. I'm Victor Rocha. My co-host is Jason Giles, the executive director of the Indian Gaming Association. In today's webinar, we're talking to CNIGA chairman James Siva and legendary tribal gaming attorney Scott Crowell about the recent decision by the Supreme Court to deny Wes Flagler going further with this case. Before I butcher it up, Jason, what the heck are we talking about?
Yeah, I mean, look, there's been a bunch of articles that come out. I'd point you to the Matt Cradell article. I'm trying to pull it up right here as we speak, where Scott and James are both quoted extensively, but all the other articles too. And even in well thought out articles and research articles with some of the journalists we know cover this industry, the gaming industry, they're just not getting it right. Let alone, you get analysts from the private sector who are, doing stock valuations based off of these cases. What was that, Deutsche Bank? And you get guys that don't even really understand Indian law, let alone the ramifications of this type of case. I mean, first and foremost, Scott, just since you're the litigator, I just tell everybody what's cert, because I mean, the conclusions I've seen writers and reporters, by denying cert, the court wants you to take away nothing. I mean, am I right on that?
Well, that's right. Yeah.
Mm-hmm.
We call it a petition for certiorari, which is to ask the Supreme Court to take a case. The Supreme Court, unlike the lower courts, where at the district court you have the right to appeal it to the circuit court, but to the Supreme Court, they only take those cases they choose to hear, and they get thousands of petitions every year, and they only grant about 1% of them. So, to put this in context, this is basically a decision by the Supreme Court that they're not going to hear the merits of the appeal that Wes Flagler is seeking, and asking for them to hear. What that means is that the DC Circuit Court of Appeals decision stands, and it means essentially the end of this piece of litigation challenging the Florida Seminole Compact. And the DC Circuit found that the Indian Gaming Regulatory Act, they rejected the district court's analysis and the card room's analysis that said all aspects of a gaming activity must occur on Indian lands in order for it to be lawful under the Indian Gaming Regulatory Act. That's just, it was wrong to begin with. We've had off-track betting compacts, since the very early years of the Indian Gaming Regulatory Act, where the primary event, the event that determines the outcome of the game, occurs off of Indian lands. So we think it was a well-reasoned decision. And what this does do now is make clear, that tribes are able to engage in statewide mobile gaming under the Indian Gaming Regulatory Act and don't need to resort or be at the mercy of state law and state legislatures in the way that mobile gaming is going to be conducted.
And Scott, that was always a big issue, which is since I've been involved in gaming and since, the Pilgrims landed, really, you know what I mean? It's always been about trying to push the tribes into a corner. And here was something where the tribes, you had technology outrunning the laws, you know what I mean? And you had an industry that wasn't going to wait for the tribes to catch up. And if you look at the laws in Arizona and Michigan, you know what I mean? There was an industry that was really pushing the tribes to keep them under the thumb of the state law. And it seems to me this really kind of opens that up for the tribes, where
Well,
now
that's
right?
Yeah, I mean, that's why I applauded this decision and was so happy to see the Seminole tribe pursue it under IGRA, because what the Cardinals are advocating would have put congressional intent in passage of IGRA on its head to actually use the Indian Gaming Regulatory Act to prevent tribes from competing in the emerging markets of the gaming industry, and so um, uh, a lot of dust is still kicked up in the way this thing is going to play out. But had it gone the other way, it would have been devastating for tribes.
And of course, our friend Joe Webster, of course, he's a litigator, so he got it right. The Supreme Court left that precedent from the lower court case, let it stand. And I just think that that's a main thing that gets lost a lot of times, Scott, when you're, hoping, especially in Indian country, because, we have an inordinate amount every year of tribal cases that go up to the Supreme Court, and we know one or two, and we always hope it's zero because we don't get always the best outcome. But just because they leave it, it's not necessarily a victory, because that means somebody can come back at a later date and under a different set of facts and challenge these legal precedents at a later date. So we're always vigilant. We work with our friends at Native Americans Rights Funds. They do have a tremendous job keeping us updated on what's going on in the lower courts. But state courts too play a role in this, in shaping and framing the law. And and James, in California, just to dispel some of the other stuff that I read in various articles, regardless of how sports betting is going to get rolled out in the state, that state constitution has to be changed, right? Amended by the voters, regardless.
Yes, Jason, that's absolutely correct.
Okay.
Yes. Yeah. And I know there was a lot of, excitement over this decision. I think it was the right decision, but I think Scott alluded it to a little bit. I think a lot of people anticipate, oh, well, this means that we're going to start having a push for, a new initiative immediately. And I think luckily we had a CNIGA meeting this coming up week, and I think everyone realized, we're going to continue the same path that we've been doing the last few years. We're going to move carefully, methodically. This opens up some new avenues for us to utilize and look at as potential opportunities, but our timeline remains the same, even with this decision.
And that's the 2026?
Yeah, I don't know. Even want to know if I want to
okay.
commit to a date.
Okay, yeah, okay. But it's basically too late to get anything on the ballot this November.
Yeah, it's not going to be this year. Yeah, I can commit to that part.
Okay.
Well, James, I mean, it's Sandarelli's, the analyst from Deutsche Bank, there were so many things wrong with that analysis, but some of the things that I thought were interesting was the fact that the threat to the industry seems to be that the tribes don't need to go through state compacting. They don't need to go through these licensing deals that you see in Arizona and Michigan, and that seemed to be the big concern about the industry. Is that kind of does open it up for the tribes in California, doesn't it?
It does, especially since this is going to be a new form of gaming conducted under IGRA. So those kind of arrangements are laid out inside of IGRA, which I think, in Arizona, they're doing it outside of IGRA and similar models in other states. So those same kind of percentage requirements don't apply. And I know that was we had a number of issues for why it didn't move forward in California, but, the approach of those large billion-dollar corporations and essentially wanting to leave crumbs on the table for tribes and take the majority of the revenue out of the state was never going to be something that worked for us. And now we have this kind of lawful path under IGRA that would allow tribes to keep the majority of that revenue here in the state, which is what we've always wanted to continue to do, the work where we sustain our tribal governments. We continue to be great community partners and great partners with the state overall. So I think having a clearer path of how to move forward for what the tribes in California have always expressed as our want and need as we move forward into this expansion of gaming, to have it laid out for us now by this decision, I think makes it a little bit easier. It's going to be a complicated, difficult, expensive path forward, but a little bit more clarity today. Yes.
Well, Scott, let me stick with that because you're one of the few to point out, hey, as James is saying, we're back under IGRA. 60% of the revenue has to go towards essential tribal government functions. And just last week, Victor and I had a podcast. You know, a lot of these states now are looking to jack up their tax rates. You know, New York and was it Rhode Island, I think, are 51%, and Illinois is going to increase it, and they're wondering it. But, you know, Scott, if you can break that down a little for folks, especially the ones that are tuning in here, because it's different for tribes. That's 60% to essential government functions. In the state, it just goes into the general fund, and God knows what happens to it, right? But tribes have always had to operate under that 60% requirement, and I think we've done a tremendous job, you know, under that requirement. You know, obviously it was imposed upon tribes by Congress, but you know, tribal chairmen have gone to jail for not, you know, sticking to that federal law, and it's, you go on reservations with new diabetes clinics or heck, new hospitals, and then they're building hospitals that just serve the surrounding community as well. I mean, it should be more of a model for how people run their lotteries, because I doubt the average state citizen could tell you where their lottery money goes or what the money they collect from the tribe, where does that go? You know, it's all a slush fund to them. But for tribes, you better believe we know where it goes, because, you know, you're looking at Leavenworth if it's not accounted for.
Well, I think that's the most critical point that needs to be made as to the significance of this decision. I don't, I've been involved with tribes, nationally for a long time, and I don't fault the tribes in Arizona and Michigan that went forward with the state law model, given the uncertainty that existed at the time. The problem that I have is with the major operators, where they have basically used those state law models to create a rent-a-tribe scheme. We're gonna, as Chairman Siva said, we're gonna give you some crumbs. We're gonna take the majority of the revenue. From what I understand, a lot of these deals are in the low single digits as to what the tribe gets, and the rest goes to the vendor. But there's 3 provisions in IGRA that protect the tribe against that, in terms of the provision that says states can't use IGRA to tax tribal gaming revenue. The tribes must be the primary beneficiary of the gaming, and the tribes must have sole proprietary interest in the gaming operation. Under that model, it ensures that the tribe is going to receive the bulk of the revenue, and then, as you point out, IGRA also mandates that revenue be used, for tribal programs. Again, to one of Chairman Siva's points about Prop 27, where these out-of-state operators were taking the money out of state, tribes, as a matter of both tribal law and IGRA, spend those funds, at home, in the surrounding community for the benefit, as it's been proven, through the economic studies, not just for the tribes themselves, but for the surrounding communities and the state economies as well. So this is a far better model, and I hope that the reality sets in with the operators, that this notion that they come in kind of like they've done with the internet lending or payday loan industry, and say, oh, we're going to rent a tribe's license and have the tribe sit over on the sideline. That's not going to happen. The tribe, there may be a role for them to bring in some back of the house expertise to assist the tribes in the operational side of things, but if they're thinking that they just could continue on this this, frankly, unconscionable model that they've been pursuing for so long in other jurisdictions. I hope that this decision is a wake-up call that that's just not going to happen.
Yeah, I mean, and real quickly, James, the road ahead you said is looking expensive, and the time, I think that it shifts the timeline back in the tribe's favor. I can tell you from a national perspective, both Scott and James, and even talking to our friends at the commercial side at the AGA, there's more and more very troubling betting scandals coming out.
Mhm.
A major league umpire has been suspended now for, we don't even know what the reason is, but it's a big deal amongst in the gambling world that this umpire, he's one of the best umpires in major league history, and he's been suspended since last September, and they won't come out and say, but he kind of broke the ice and came out and said, I didn't do anything wrong with regards to placing bets. I don't know what that means, but this stuff is has got to be a little bit more thought out. And in the FanDuel DraftKings model of like, let's just get it out there and get every state to legalize it, and then the tribes can jump in when they can. It probably, and Congress obviously wasn't going to do anything because they can't even pass a budget barely. James, I think it's going to accrue to the public bettors' benefit that we can analyze some of these situations a little better, and tribal regulation is, as far as we're concerned, it's the best that there is. We have three levels of regulation. We got regulators from commercial gaming, tribal gaming, state gaming. They're all working together, and they change jobs freely from one sovereign to the other. And we really think we have a good system in place. But what are your guys saying in California, James? Because it's the next big area, really. And you can just throw the whole panoply of internet gaming in there as well. Yeah.
Yeah. I mean, it's kind of a natural consequence of the expansion of any form of gaming. Is you're going to have some expansion of the illicit activity that comes along with it, and it's a small percentage. But when you use these kind of models that are being pushed forward by the larger sports betting companies, where they don't put the time and effort to either do some deeper dives into the market research, because they're worried about just getting into the market. They just need access to the market. They need access to the people. They're not worried about problem gaming, these different activities that come up with the MLB umpire. I was just reading about that the other day, and I think he didn't think he did anything wrong because he didn't lose any of his bets. But as we move forward here, and you mentioned it as far as the regulation of tribal gaming, I always tell people we're the most regulated industry in this country. The most thoroughly regulated, the most well protected. And here in California, we really pride ourselves on that, on having one of the safest industries, the safest environments for gaming, which is not always the case in other places. So as we look at this, we're hopeful that this now will force these kind of big corporations to continue to listen to us, because I know there's been a couple companies that have really tried to do a 180 on this and come to the table and want to hear from tribes. And I hope that this will put some force behind that we'll see some action and not just some words, when they realize the models they've used in the past aren't going to be the same models that work in California, that our careful approach, our protection of this industry that we've built up from nothing over the last 3 decades means more to us than just adding another percentage to the bottom line. And so that's always been our approach, and that'll continue to be the approach. And by doing that, I think we'll continue to lessen those illicit activities that happen, stop some of those scandals from becoming widespread, and be just kind of these little moments that pop up here and there that have to be dealt with. But overall, I think that's always been our approach, is to do this carefully, well regulated, protect what we built. And I think now they're going to have to listen to us a little bit more.
James, you mentioned about them listening. It seems to, you got the California tribes have been very consistent in their messaging, which is like, we are not going to be erased for the brand, for some corporate brand, be it anyone in the SBA, pick a company. It just seems to me this decision really reinforces where you guys were before. It just makes your ground more solid and gives a little more definition to what the future is going to be, which is the tribes are going to be firmly in charge. You know, there's no ifs, ands, or buts around that. It seems to me this is going to be predetermined. You know what I mean? So it seems to me the industry is going to have to either figure out and accept it or go away. I don't think there's any other option here. You know, either they're going to be part of it, be an ally, or just go away. You're not getting into the California market. Now, all this is still yet to be determined, but my point is, it just feels like your position is now reinforced and starting to be written in stone, which is scary, I think, to the rest of the industry, because they were looking around ways to usurp tribal leadership, to divide and conquer. And I think people will find that that's much more difficult to do. How do you think this makes you feel? How does this make you feel from a leadership position?
Yeah, from a leadership position, I think it's always good to have that reinforcement of the principles that we've been using and have adopted as we approach this. And now to essentially have our position solidified from an outside source, from, you know, it's the Supreme Court, seeing what other tribes in other states are doing. Because it's easy to take a position. It's always difficult to know if that position is actually correct in the right path. And so I think having some outside decisions supporting that position, because it's been a lot of work, it's been a lot of difficult meetings and moments to continue to hold on to that center position and hold on to it amidst all of these initiative fights and expensive media campaigns and all of these different things. And like you mentioned, like the attempts to conquer and divide tribes here in California have come about in a manner of different ways, whether it's, you know, the initiative process, whether it's just, you know, trying to change their approach and getting in with tribes and not realizing that it's the same tactic, just with a different face on it. I think it adds some reassurance. But for us, the fight was always going to be worth it. Like, we were never going to just back down from these guys. But it does help, and I think it gives us something else to lean onto. And I applaud all of the leadership in California that's, you know, been holding strong to their position from the very beginning. When we first started having meetings, to me, it always seems like a lifetime ago, because it was pre-COVID, and everything pre-COVID seems like a dream almost. But it's been a long time, and it's just some, you know, reassurance that our position has been correct and will continue to be correct as we move forward.
And if you stop and think about it, if you take this hypothetically forward, you know, there's a possibility that someone like DraftKings doesn't get into the market. The name DraftKings doesn't get into California. Instead, you will see Morongo, you will see Pachanga, you will see Paskenta, you know what I mean? But what you won't see is DraftKings. What you won't see is BetMGM, you know, because... And if they come into the market, if we do it right, you know what I mean, that will be a violation of California law, which will be a violation of their license. It will put their licenses in trouble from around the country too. So I think, hypothetically speaking, I don't think people realize what a game changer this is, because I'm still diving down this hole, you know, and rabbit hole, and the potential's there. I just don't see the tribe screwing it up. I think if you look at the last 30 years of getting it right, I think you will see the tribes do it absolutely right for their benefit, not for the industry, you know?
And with Scott, one last 50,000-foot question. IGRA's now 36 years old. It's never been amended. You know, aside from the Seminole case back in the 90s, it's most of the provisions have withstood, or at least, you know, we've been relatively successful in the courts under IGRA, whether it was Class 2 or, you know, now this interpretation of compacting. But just from your aspect as a litigator, Scott, I mean, is IGRA still, was it as forward-looking as we think it is? Does it need to be amended? Do you see, or is it serving its purpose in protecting tribal gaming on the reservation?
Well, for the most part, I think the developments with West Flagler is a reaffirmation that IGRA is working, and that there probably won't be any quick run to fix it. Had it gone the other way, the New York Oneidas and Representative Carrera had already contemplated legislation that would have clarified that Seminole's able to do what it's intended. I don't think those pieces of legislation are needed at this juncture. That being said, there's still a couple of unanswered questions as it comes out of this decision. This decision shows what a willing tribe and a willing state are able to do to authorize mobile wagering. It doesn't address the question, although it's helpful to tribes in those states that have already authorized mobile sports wagering for non-Indian entities, but it doesn't make clear that those states must now negotiate compacts or compact amendments to allow tribes to do the same games. And then we still have, the 1994, 1996, I can't remember which year, the Seminole versus Florida decision that found that Congress didn't have the constitutional authority to abrogate state 11th Amendment immunity in lawsuits brought by tribes. I know there's a commitment of this administration to try to provide an administrative fix that well, there is one for everybody except the 5th and 10th circuits that struck the Part 291 regulations down. It's still valid in all other jurisdictions, but I think there's a need to strengthen that. And if it can't be done by administratively, I can't rule out that there would be reasons to amend IGRA. The problem in the past has always been that if you open it up to make technical corrections, you're opening up for like Dianne Feinstein had a terrible anti-tribal agenda that she was insisting be included in any technical amendments to IGRA. So I think this decision reinforces the validity of the act and suppresses any efforts to try to amend the act in any time soon. So yeah, given the fact that it's worked for 36 years now is pretty telling, and it did expressly identify that in the legislative history that it wanted to position tribes to be able to take advantages of advancements in technology and emerging markets, and this decision validates that congressional intent. I do want to make a comment just on a policy. You had pointed out scandals coming out, and I want to pick up on Chairman Siva's comments about tribal interests are not, we're not out there just to maximize profit. Protecting the integrity of the industry is really critical, and CNIGA recently voiced its concerns to the California Attorney General's office over daily fantasy sports expansion, and particularly these proposition plays. And you're seeing it in the lawful sports betting market as well. And that's where we have a major concern that it's a huge scandal waiting to happen, because when you have these in-game plays and these proposition plays that are a big part of the recent expansion of the industry, it puts pressure on individual players, because you're no longer betting on the Chicago White Sox. You're betting on Ohtani, is he going to hit a home run in his next at bat, or is LeBron James going to score over 40 points in the next game? And it's not just stories of of people trying to manipulate those players, but actually threatening players if they don't do something, and that's really vulnerable, and arguably irresponsible in the way that the industry has hugely expanded that segment of the market. I noticed, the Minnesota tribes, had agreed to not authorize in-game play as part of the measure that didn't quite get out of the Minnesota legislative session this last year. Those are policy issues that, frankly, I have a much higher level of comfort of the tribes looking at those policy issues and regulating them than I do with the operators themselves that are motivated by maximizing profit.
Right.
Well, you know what, Scott, I mean, hypothetically speaking, will this change anything for the Minnesota tribes coming back? You know what I mean? I mean, it kind of seems like the ground shifted a little bit.
Yeah, Scott,
This
I
is-
mean, not just them, Oklahoma is another big market that, and then, we know California's got to get that Constitution amendment amended, but, someone did ask, what does this mean for if you're a tribe out there, Oklahoma tribes in Minnesota, we can go down the list. I think one thing, Scott, to point out is, IGRA allows tribes to have as much gambling as the state has authorized. So, Stitt in Oklahoma has been threatening, I'm just going to legalize sports betting and just open it up. I don't think tribes are afraid of that, and tribes are not afraid to compete. And how do you think see this rolling out? Because I've been saying state by state basis, because you just can't get over the vagaries of who your governor is and who your legislature is. But how do you think this is looking for, like Victor said, Minnesota?
Well, I do think you really have to break it down state by state and how the markets worked in every state. But I believe in those states like Minnesota and California, where there's either actual exclusivity by the tribes or substantial exclusivity. It include like New Mexico and Oregon and in that boat. That I think they should take a serious look at this model. The legislation that almost passed in Minnesota, would have been more akin to Michigan than a state law model, where I think that to have the protections of IGRA, I think I don't represent any Minnesota tribe, but I think that they should take a very serious, hard look at an IGRA model for expanding sports wagering in Minnesota.
That's huge. That's huge. That has the potential to be a complete game changer. And more importantly, I think it feels advantage to the tribes. You know what I mean? Going back into this conversation, especially in a state, the governor appointed Melanie Benjamin to the Gaming Commission Board in Minnesota, which was great. And like everybody's losing it's her and someone else. And I love Melanie too. So she's great. She has plenty of experience. And as I posted on Twitter, I think that maybe putting that HHR bill wasn't such a good idea in Minnesota, because now you have Melanie on that board. So, that's it'll be interesting to see what happens over there. Let's take a couple questions. I think one of the first ones you have is, should tribes and states with commercial model already in place try and amend the law to adopt an IGRA governed model? And I think that one's kind of pretty self-explanatory in what we're talking about. And I think the main issue of what this is, and you touched upon it briefly here, Jason, is that if you have a crappy relationship with the governor, it's going to be harder to negotiate changes. I think, tribes in Oklahoma, their issue is they have a very hostile governor that's trying to literally keep them on the reservation, so I think that's a big difference. Every state is a snowflake. Every governor is different. Each state is different. What's going to happen if Wampanoags go forward with their casino? Do they get sports betting like, BetMGM and the rest of these guys and win and stuff like that in Massachusetts? So there's so many questions that just pop up and have to be answered. But I think the main one is it all depends on the governor at this point, doesn't it? Right, Jason?
Yeah. I mean, I agree. What do you think, James? Because I mean, both you and Scott work in states and have
Yeah.
tried states that are, dealing with, different types of governors. Even, the difference between a Arizona Democratic governor and a California Democratic governor is still pretty vast. Yeah.
Yeah, I think it's a complicated question. I don't think there's a straight yes or no answer. I think it depends a lot on your current situation in your state. Even here in California with Governor Newsom, who has probably been the most pro-tribal governor the state's ever had, there's still a number of issues. We still see a number of compact disputes and issues over, what's allowable inside of the California compact and what should be allowable according to IGRA. So we still have disagreements. Now, we're not anywhere near the position of the Oklahoma tribes with Governor Stint, and I can imagine how difficult that situation is. But yeah, I think it just depends, like, on what your relationship is with the governor, the structure of that state, and how their legislature works. Because I know different states have different structures on how you move forward. I know the proposition system in California is pretty unique. So yeah, I think it depends, but I think if there's the opportunity to do so, it's definitely something to give a consideration to moving towards the IGRA based model.
I think part of that
Go ahead,
is-
Scott.
I think part of that is the question of, in some states, you might not be able to put the genie back in the bottle. If you have a situation to where, like you mentioned, Mashpee Wampanoag, Massachusetts has already authorized so many of these non-tribal commercial mobile sports wagering licenses that a tribe coming in with the 60% requirement, why would a major operator go with the Mashpee Wampanoag for 40% when they could go with a tavern or a sports franchise for 95%? So it's going to be difficult for tribes in those types of circumstances to be able to compete under an IGRA model. And it's just unfortunate. I mean, Arizona, the tribes have half the licenses and roughly 5% of the revenue, primarily because of the branding situation you referred to earlier, Victor, where all the major brands went with the non-tribal commercial operators and are dominating the market. How you put that genie back in the bottle without being responsible, or sued by DraftKings and FanDuels in that situation, becomes really difficult or problematic. But that that doesn't mean this may be a lesson for the Arizona tribes if and when the Arizona market expands into online casino gaming, to use an IGRA model for that and keep the current sports wagering market kind of isolated.
That's fascinating, Scott, because I don't think many people talk about that. I think people tie sports betting and online gaming as one and the same. You know what I mean? If we have sports betting, then we have online gaming. I don't see, and I haven't seen a rush by the state of Arizona to correct any of those issues either. They're talking about a new license. Yesterday, there was an article about the hockey team. They didn't get the land deal. They're getting ready to pull out of the market. They're saying, you were supposed to get a license. Now they're saying might not get a license in Arizona. But I don't see the state, which they have a friendly administration now, rushing to correct the issue. So I think you're right. I think it's going to be harder once that it's laid out. It's going to harder to get the state to go back to a compact model, and that's a shame for the tribes that got done already. I think that was part of the strategy for the industry. The sports betting industry was, run fast, break things, get an advantage. But as Steve Ruddock said, when it came to California put an end to that strategy. As we talked to him a couple of weeks ago or a week ago, now everyone's starting to take a look at sports betting as a way to generate revenue and not just an amenity that is harmless, but something that generates real revenue that's just flying right out the door. So, I think everyone's going to be reevaluating what sports betting and online gaming. But to go back to the question is, I think it's going to be hard to put that. I like better way to the genie back in the model. I like that better. I think that's a better way of expressing it. So another question here: as long as servers accepting bets is on Seminole lands, patrons can wager using their phones from anywhere in Florida, according to the Supreme Court's ruling. How does this ruling affect all American tribes in terms of their ability to regulate sports wagering going forward without state intervention, deadlines for implementation, or new regulations? James, how can we have sports betting in California when the California Gaming Commission is a mess? You know what I mean? How are we going to have sports betting in California with those guys? That's a good question. I'm glad somebody asked that question because it's about time. You know what I mean? We have an opportunity to change what California is. So
Yeah,
I will let you jump
absolutely.
into that mess. I'll let you jump into that mess, James.
Yeah, and it is a mess. I mean, that was a concern over even with the two initiatives moving forward, that the California Gaming Commission does not have the expertise and is not equipped to regulate sports betting. They just aren't. And so moving forward in California, like most things, the tribes would be the ones to step up and make sure we do it correctly. We would utilize our own gaming commissions to make sure that we can step into that. But also, it might be another opportunity to look at, maybe this is where we start to limit the state's overall regulatory authority as far as it comes to gaming, because they have shown time and time again that they are both inefficient, they both do not utilize the funds they are provided by the tribes to do the regulatory process correctly. They are less than transparent, to say the least. So yeah, this would be an opportunity to really lay out where their deficiencies are and where we are proficient at the same time.
Do you think Melanie Benjamin would join them? Do you think we can get Melanie to join them too? I mean, she is good. And,
yes.
but, I mean, I joke, and it really does bring the bigger issue. I mean, you look at the money laundering again and again and again and again, and the licenses are still there. And, I mean, it's just absolutely, it wouldn't fly anywhere else. But in California, it's baked in the process. You know what I mean? This is a political bureaucrats. They call themselves citizen regulators, if I remember, if that was a while ago. But in California, man, it's just not going to fly, especially with the tribes and the way, so I know I'm causing a lot of trouble and stuff, but I think at the very basic, that's something we have to look at in California, so Priscilla, I hope that caused a lot of problems. So Jason, go ahead. Get me out of this.
Scott, real quick, Scott, let's just take two more specific examples, New Mexico and Wisconsin, where, they have substantial exclusivity, as you said. I mean, because someone asked a question here, I think this decision will help them. They're probably will get a chance to renegotiate something here in both those states in the near future. And they both have, the tribes are operating sports books, but I don't know how wide they're in New Mexico, that they don't have internet sports betting yet, but I think in Wisconsin it's just limited to the tribe's property. But I think it's going to help the tribes in those two states, wouldn't you say?
Well,
Scott?
yeah, that's right. I mean, the brick and mortar sports betting, is a nice amenity to add, but it's not, it's not the kind of revenue generator that mobile sports wagering, it doesn't even hold a candle when you look at the projections there. But those are two situations where you have reasonably friendly state governments and tribes already, having substantial exclusivity and excellent track records in terms of regulating, the gambling industry in those states. I would think that those would be two excellent candidates where the tribes, preferably working together, would be able to approach the governor, to adopt a Seminole type model. Now we all have challenges. One of the things that hasn't been talked about yet is, in Florida, there's two federally recognized tribes, and the Miccosukee tribe and the state of Florida, kind of turn their backs against each other a long time ago, and Miccosukee operates a successful Class 2 facility outside of Miami, but the only compact is with the Seminole tribe. In California, Chairman Siva has the task of trying to herd 110 federally recognized tribes in terms of how we're going to figure out how that model could work there. You're dealing with a more manageable number of tribes in New Mexico and Wisconsin, but still several in figuring out how to do it. Going to Victor's comment earlier, just opening it up and not addressing this branding question, just creates another venue for a small handful of winners and a lot of losers, and because the top 4 or 5 brands are going to dominate 80%, 90% of the revenue. So those tribes have to tackle those issues, and the recent developments with West Flagler raises those questions but doesn't answer them.
And Victor, I think the commercial guys, once again, if they would open their minds a little bit and explore even what tribal sovereignty means, and just respecting that aspect of it. I know they're making overtures now. They're hiring a lot of tribal folks and folks from tribal gaming facilities and from the tribal gaming industry. But, there's still maybe models out there where, in Oklahoma, where if they went in, the one thing they have, Scott, that tribes are going to have a hard time recreating is just the mass and the ability to spread risk. And that's a big deal, because we've seen, there's been years where sports books have cost casinos money, and they've cost corporations money. When Hilton was big into it, they took a bath one year. So, it's just creative folks need to get out there. And someone asked about, what does this mean for data storage in the future, and all that kind of stuff, because that's really where it's at, is getting people's data nowadays. Again, there's got to be some thinking people out there that can make this work. But, James, you guys experienced firsthand that you're just coming in and they don't even want to really talk to tribal leaders. It's just take it or leave it type stuff.
Yeah, absolutely. They came with, models that had worked for them in other states with other tribes. But essentially, just like you said, they came to the table. It was like, here's our offer, take it or leave it, because there's 190 that we could put the same offer to and potentially get a yes. So we'll see. The question about the storage of data is interesting. I know there's been some panels happening on, and I think one at CNIGA, over, how does tribal sovereignty translate into a cloud-based platform? Do we still have sovereignty in the cloud as the data exists? How does that translate over? So as we move forward into models like this, where we're using these servers and having all this information, that's something that we got to consider. And how do we translate that? How do we lay that out? Is there a legal path forward to continue to promote and protect tribal sovereignty in a digital age?
Mm-hmm. Exactly.
Well, I mean, listen, we have an opportunity to rewrite, and that you get the big fear of the industry is exactly that. Are the tribes in California going to rewrite what the industry is? And the answer is yes. They are, in the end, California will redefine what the industry is. Everybody was waiting for it. Flagler just reinforces that the tribes are in charge. The relationship with the governor is very important. And, this was an industry that wasn't waiting for the tribes to catch up. Everything that they did, listen, we've been dealt with aggressive people for, I've been involved now for 25 years. Scott, you're probably twice as long. Sorry, Scott. We've seen this, and, we knew what was coming, and now they're asking for mercy, but tribes in Arizona are still, there's no rush to renegotiate those compacts. There's going to be no rush in Minnesota or Michigan to renegotiate that or to put it under to IGRA. I think those guys are going to be trapped under that model for a while. I think what the glimmer of hope is what Scott said, which was about online gaming, whether they'll treat that different and where the tribes can go forward as sovereigns instead of corporations, you know, and I think that's a real big issue here that I see going forward. What are some of these other questions we have? I think Rebecca Giddens says, any information, inclination on tribes in Washington to explore IGRA Stout OSP? You know, we were just up there when this whole thing went down. So, you know, it's still too early at this point to decide, or to make it, you know, the tribes have been in the driver's seat there for a while. They have a good relationship with the governor, with all the elected officials. If they can't do it, who can? You know what I mean? I think what you're looking at is something like California that is, it's a green field. We have an opportunity to rewrite what the industry is, what sports betting is, what online gaming is in California. And I believe in my heart that we will take that opportunity. At least that's leadership, right, James?
Absolutely.
Yeah.
Mhm.
So we are almost done
Yeah.
here. We
Scott,
have some more questions.
We're gonna, bring this up at our mid-year, which is also at Tulalip in Washington. And we'd love to have you guys come out and talk some more about this. And our friends in the Northwest and the upper Midwest, the Montanas, Dakotas, they're up against it probably maybe even worse than the Oklahoma guys. At least the Oklahoma guy is out there saying, "I hate you." Trying to talk to the Montana guys and break that monopoly is just, talking to a stone wall. So, you know, again, Scott, like you said, we're going to have to tackle this state by state. And I know it's difficult, and it seems to be particularly difficult for the commercial guys trying to do this, but they had no problem going into Pennsylvania, West Virginia, Delaware, Maryland, and respecting their state sovereignty and working with the state legislatures there. It's no different. You just go meet with the tribal leaders. You come to shows like ours. I know that's a crass plug, but people don't know where
Click
to
at the bottom, subscribe over here, click at the bottom, something like
People
that.
don't
Are
know.
we supposed to do that?
The number one thing we get, where do we meet tribal leaders? Where do we see them? That's what we're trying to facilitate. So, it's not hard. And,
Yeah. And by the way, I'd like to answer the question that Ernest asked you about, what about Oregon? Was it FanDuel up there? They got a poison pill written into their contract, right? Anything that goes up. And so, but that's a classic example of what we're dealing with. This is an industry with no scruples. You know what I mean? If you're looking for honor, don't look at this industry. Don't look at sports betting for honor or integrity. These guys are running as fast as they can. Go ahead, Scott. I know you want to cuss. Go ahead.
That may be a poison pill that DraftKings and the state of Oregon will have to swallow, in large part because of this decision. For those that what Victor is referring to is, they have a contract with the Oregon Lottery now to be the sole provider of statewide mobile sports betting in the state of Oregon. They get 49%, but if they enter into a single compact for a tribe to offer the same game, their percentage goes to 85%, and if they negotiated with all Oregon tribes, it would go to 95%. One of the unanswered questions, the state of Oregon actually used the district court opinion in West Flagler to say, tribes, we have no obligation to negotiate a compact with you. But now you have a state that has authorized statewide mobile sports betting, and the tribes are requesting compact amendments to allow them to offer the same game. In my view, they have a legal obligation to agree to such an amendment, and whoever negotiated that contract on behalf of the Oregon Lottery either set out to try to punish the Oregon tribes, or was so completely ignorant about the impact it would have on the tribes. If they wind up having to live with that contract with DraftKings, so be it.
Ouch. Ouch. You know what I mean? Ouch. Some ears are ringing. Some ears are ringing in Oregon right now, man. Yeah.
Alrighty.
So
Yeah, Victor, I'm gonna have to jump off. I've got folks here waiting for me now. They showed up a little early, but this was tremendous, and I want to carry this on at our mid-year and also Oklahoma
Yeah.
Indian Gaming Association in August. This will be great.
yeah, there'll be. Listen, we're just starting to dig into this thing. You know, Chairman Siva has his work cut out for him. First of all, congratulations on your re-election as vice chairman of Morongo.
Thank you. I appreciate that.
Congratulations, man. You're doing such a great job. I think one of the important things here is if you look at California, what's always been important is that they've had great leadership. And James, you're doing a phenomenal job. And as a California tribal member, I just want to say, good job, man. Good job.
Thank you. Thank you. That means a lot, Victor.
Yeah, really too. And Scott, the legendary tribal gaming attorney who fights other gaming attorneys. You're like a ninja or something, man. You know what I mean? That's what we send him in. Yeah, we use a trebuchet and we just shoot him into the other camp. You know what I mean? So, Scott, thank you, brother, for being a phenomenal person that you are. You know, when I first entered this industry 25 years ago, you were there, man. You were at that door saying, welcome, come aboard. I still remember our lunch, our dinner, you know, in LA and stuff like that. So it's a great victory for tribes. I think we have reasons to be optimistic. You know, it's good to be Indian. You know, it's good to be a tribe Indian today. So, Jason, what are you going to end it up with, brother? Just say goodbye.
Oh, you're muted,
you know,
Jason.
No, he's
Scott's
not.
Scott's the litigation expert, so thanks for coming on, Scott, and breaking it down and just, you know, educating folks on what it really means when you in Indian country when you get a victory in Supreme Court. So thank you. And James, we'll talk to you soon. You know, congratulations again.
Thank you.
Right.
Yeah, I'll be a mid-year. I'll be at OIGA. So
great.
That's right. And he'll be at G2E. So we'll be talking to it at G2E also. We'll be talking mid-year. We'll be talking it on airplanes, cafes, in lines, you name it. We'll be talking about it. Again, everyone, thank you so much for all the questions. Sorry we couldn't get to them. Jason, I know you have guests.
Yes.
On the 17th, we have Joe Webster's coming in to talk about it and what the hub and spoke, and we're going more. So we're not done with this issue by a mile. So thanks, everyone. Talk to you guys soon. Bye.
Excellent. Thank you.
Bye.
Thanks, guys.